Welcome to my presentation on the Family Educational Rights and Privacy Act. My name is Matthew Poliak, and this is Module 8 for Educational Law. There's certainly a lot of confusion with reference to FERPA guidelines. There's a lot of questions that come up. For example, what do we do with our old documents? And do we have to worry about our vendors mining our data? How do we deal with older students, perhaps an 18-year-old that's no longer a minor asking for records? How about sharing eyewitness experience with media after a health crisis or perhaps an outbreak of violence or a school shooting? These are all questions that would come under the auspices of privacy, and as a result, they're issues that we need to treat with some care. Confusion is far too common. There's just a lot of information on the subject, and FERPA laws have been altered or changed quite a lot since they were first instituted in 1974. Just in the last few years, we've had 40 states add 120 additional privacy laws that overlap. So there's a lot of information, and a lot of it can be a little confusing. To help combat this confusion, the U.S. Department of Education established the PTAC, putting together a thorough collection of information to help make our obligations clear. The Privacy Technical Assistance Center is designed to be a one-stop resource where you can find information on how to maintain data confidentiality, how to deal with security issues, and privacy. So that's a resource that is quite valuable. Under the direction of Betsy DeVos, the Department of Education published a 22-page frequently asked questions document to act as a guide for schools trying to navigate the confusion surrounding FERPA regulations. There's a lot to assimilate. Rather than trying to take it in all at once, it may be best to simply refer to it whenever needed. Even so, there are a number of separate but related issues, so let's tackle a number of them one at a time. Raising awareness is a quick first step, and it's perhaps the first place to start. This is the kind of thing that school districts can do. We can then implement policies. Those policies would deal with everything from making sure that our vendors have signed non-disclosure agreements, to making sure that we understand that all documents should be shredded before being disposed of. All documents that would contain private information, of course. We'll need to spend some time training our employees on those policies. Those employees would reach all the way from all school personnel and outsourced parties that would have access to that information. Anyone from consultants and attorneys, perhaps health individuals, folks like the school nurse, for example, would, or a school psychologist would apply as well. All of these folks would need to be trained in those policies, and steps would need to be taken to encrypt data. All of our files, all of our emails, anything that would potentially contain information that could be mined by outsiders should be encrypted, just to add an extra level of security. Now, speaking of security, security cameras are an issue that, as they are now ubiquitous, popping up essentially everywhere, are they a privacy violation or not? Well, when it comes down to it, security cameras, it's been determined that, generally speaking, would not constitute an invasion of privacy or a violation of FERPA regulations as long as they were used in places where there was already a low expectation of privacy. Places like hallways and stairwells, and the places where students know that other people can be watching them at any time. On the other hand, places where the expectation of privacy is significantly higher would prohibit the use of security cameras. Obviously, putting a security camera in a locker room or a private bathrooms would be a bad idea. Now, audio recordings are another matter. It turns out that Illinois, where my school district is a two-party consent state, which means that everyone must give permission before they can be recorded. We could perhaps get away with it, with recording people without their express permission, if there were signs posted indicating that just being on the premises grants permission. But that has the potential to create some serious legal issues for the school district, so this should be done only after consulting with legal counsel. Generally speaking, I would think this is a bad idea. Now, law enforcement officials are another issue at my particular school, as we have police officers in this school at all times when students are present. So this is an issue that might come up. It turns out that law enforcement officials, perhaps even off-duty officers or a school resource officer, if they are an employee of a school district, they generally would be considered a school official to whom schools may disclose without consent educational records or the personally identifying information contained in those records. Of course, certain conditions and limitations would apply, and when it comes to specific details, it might be best to consult with an attorney. These are my references. I hope this has been enlightening in some way. Thank you for your attention.